Good morning and possibly good afternoon to everyone. Depending on where you are, I see we've got participant count coming up and up, so we'll give everyone just another minute or two to join in and before we get started. Okay, we're a couple after, lots to cover, so let's go ahead and jump right in. As you know, we're here today to talk about FINRA expungement. There's really a sea change that's going into effect here in just a few weeks. It's been a process that's been years in the making, and is really relevant to a wide span of cases. We've got the all-star lineup here today to talk through these issues. Andrea Wells, myself, and Katie Wilson are here in Birmingham, Alabama. And David Hampman is up in the New York, New Jersey area. And John Kincaid is in our Dallas office. All of us work almost exclusively on securities litigation matters, whether it be an arbitration or court or regulatory matters, and all deal with expungements in many forms and fashions through our respective practices. You can obviously look up our full bios on the website, but I think it's probably best that we just jump right in. Before I do that, a couple of housekeeping matters. There is a Q&A button that you can use. We've got a lot of participants, so I'm expecting that to be a pretty active chat. Submit your questions and we'll do our best to get to them. If we can't, then we can certainly follow up afterwards. Also, CLE codes. We do have CLE approval for this presentation, so we'll have a couple of codes that we'll provide through the presentation. You'll get an email with a survey after the presentation, and that's where you'll enter those codes to get your CLE credit. So with that, let's jump right in. And Andrea is going to start with the overview of expungement. Give us the basics, Andrea.
Absolutely. Well, hi, everyone. Welcome. Thanks for joining. First, today, we're going to start off with a little bit of what hasn't changed to give you some perspective on what is changing. And so I'll quickly go through that. We'll start with FINRA Rule 2080, which remains the standard for seeking expungement. It has not changed, and it offers the option to proceed in court or arbitration with an expungement. If you obviously file an arbitration, you have to get confirmation in a court, and to do that, you have to name FINRA as a party. So that has not changed. And on the next slide, you'll see that any of the any one of the grounds rather from FINRA Rule 2080 is still the standard of what you have to prove. That burden hasn't changed. Obviously, the more grounds you can throw in, the better. Most often we focus on the falsity of the allegations. We throw in arguments that information in the claim is factually impossible and or clearly erroneous. To do that, we usually focus on inaccuracies in writing in the original statement of claim is always a good place to go. And then in other cases, we focus on the financial professional's lack of involvement in the claim. You'll see that a lot in product cases where you have a product failure, or a market case where losses are the result of market forces or industry forces, with respect to a certain asset class and not the financial professional's advice. So those are the things that haven't changed.
Great. Thanks, Andrea. In terms of methods of requesting expungement, they're going to requests can still be made as a part of the customer arbitration. you can request it during the defense of the customer claim. If the arbitration proceeds to a final hearing, the request may be decided by the arbitrators together along with the customer claim. If the arbitration settles, then the associated person must pursue expungement through a straight-in request. The straight-in request or a standalone request, that is where the associated person files a separate arbitration requesting expungement of a customer dispute. And to point out, to follow on Andrea's discussion, the rule under 2080 under B1, the 3 grounds, those are the exclusive grounds now. So it would appear under the new rules that some of the equitable grounds that were raised before are not available any longer to the associated person. And then Katie's going to discuss some other changes that have been made. Or nope, I'm sorry about that. Switch to slide. I'm going to talk about direct to courthouse. This is something that I've participated in several times and have been successful in, as other members of the panel have, in representing associated persons going directly to the courthouse when that opportunity arises. What you will required to have is FINRA will need to waive service, or if you do sue them, name them as a part of the lawsuit, you'll need to get their agreement not to oppose the relief, because they can always come in and oppose the relief. And then also, Andrea will talk about later that states can come in and oppose the relief. The question, I think, that would relate now is whether courts are obligated to follow Rule 2080B1, the 3 exclusive grounds of impossibility, mistake, or falsity, or whether the courts can also look at some of the equitable grounds. There'll be arguments that are going to be made on both sides of that. I would think that FINRA, this is my guess, that FINRA would oppose an expungement that goes direct to the courthouse that would rely on the equitable grounds, but that's just a guess on my part. One thing that we have found in seeking FINRA's agreement not to oppose the expungement is that we point out the unique circumstances of why we're going directly to the courthouse, that we're not trying to create a precedent or create a public record precedent of going straight to the courthouse. And that's one thing that we've been involved with FINRA on that. We've also done it when there's been an agency or a complaint outside of FINRA. We had one where a complainant ultimately made a customer complaint. It was denied by the firm, but then the agency that actually looked at the complaint from the outside was the Texas Department of Insurance, and it denied the claim. And so in order for the expungement, we went through court and pointed out that FINRA, a number of state regulators had the opportunity to investigate the claim, all declined to do so. And then once we got the clear from the Texas Department of Insurance, we explained to FINRA that that's why we're going, because the actual complaint itself or an investigation of it was not done within FINRA. A lot of times FINRA may also do an investigation and determine that they're not going to go forward. And in that case, we point out to FINRA that they've already reviewed the file, determined not to go forward. They've made an internal determination on the regulatory and enforcement side. And so we point that out. We also point out when a claim has been delayed, that a customer has had the opportunity to proceed with a claim in dispute resolution after their complaint has been denied over the passage of time, have not done so. And we point out that that's another reason to FINRA that we would be going direct to court. There's also going to be unique circumstances of the matter that you'll want to be creative about and come in with a good hook or a good reason of why you're going direct to courthouse. Direct to courthouse does remain a viable option. We pointed that out in the release below where that continues. And then one last thing relative to direct to courthouse, it's going to be interesting, and I think other members of our panel may talk about it as well. With these changes in the rules, will you see more associated persons going direct to the courthouse, that's going to, it's going to tax FINRA, I would think, from an ability to defend expungements if it chooses to do so. It may also create more opportunities for states to come in and oppose. And then the second process is the confirmation of the award.
Hey, John, before we get over to the confirmation, we had a couple questions come in about timing. You know, there's obviously the 6-year eligibility rule within FINRA. What sorts of timing considerations when you do go directly to court are there? Statutes of limitation, does that 6-year rule continue to apply?
Yeah, I think that there'll be arguments on both sides of that. If I were in the position of defending the associated person, I would argue that if it's beyond the 6 years, that that is a eligibility within the forum rule. And so there are carve-outs under the rule, I guess 12.206, or I don't remember the number off the top of my head, but there are carve-outs for litigation under the rule. So I would argue to a court that that is just for eligibility in the forum. But you also have the constraints now under the new rules about how the passage of time when you must go in. And so, you know, you're going to find different judges that may lean toward the regulatory and continue to look at that from just an equitable discretionary standpoint. So I think you need to be prepared for arguments about why that eligibility rule would not apply if you're beyond the 6 years.
Yeah, and of course the 12.206 or 13.206 eligibility rule specifically invites filing in court. Like you mentioned, it's a forum rule. So
right.
I think that's a pretty solid argument for someone looking to file in court. But kind of an overarching theme I'm hearing from you is that a lot of these issues, when you're going directly to the courthouse, remain to be seen, and there's probably going to be some variability depending on the judge and circumstances, and it's you know, certainly more gray areas when
yes, because with the courthouse, the opportunity to have argued the equitable grounds for expungement along with the 3 specific rule grounds under 2080, I think that's going to be of some development, you know, and we're just going to have to wait to see what positions FINRA takes on that.
Okay. David, you want to talk about the confirmation process?
Yeah, thanks, Joel. So the new rules don't directly implicate the confirmation process, but there have been some recent updates in the confirmation process that I just want to highlight as we're going through the entire expungement process. The first is the waiver process. The rules don't say that waiver is required. The rule says that if you're not naming FINRA as a party, then you have to seek waiver. There is a new portal that FINRA has been using. You used to be able to just submit documents via email. Those aren't accepted anymore. There's a separate FINRA Rule 2080 waiver request portal that FINRA did a great job developing, and I was one of the test subjects on that, providing feedback, but it runs pretty well. So again, it's not required, but you know, we've been recommending to go through the waiver process, especially in customer cases, because you really want to have a preview of whether FINRA and the states are going to oppose the confirmation. And then in the court confirmation, again, the award for expungement purposes, in order for FINRA to execute the award, it has to be confirmed in a court of competent jurisdiction. You know, if you go through the waiver process first, there's usually not any issue with the court confirmation. And in those, you know, we typically name FINRA as a party to the court confirmation, since we are seeking injunctive relief. And it's important to maintain an open dialogue with FINRA about the confirmation. I think the next slide that we're going to go through is expungement over the years, just to see Joel mentioned, this has been a progression over the years to where we finally are. This is kind of the culmination of all the rule changes that we're dealing with. And I'm not going to go through all of them, but I want to point out a couple of important ones. The first one on here, May 2009, is the rules included reporting requirements when financial advisors were not named parties in arbitration. So as long as the firm could reasonably identify the financial advisor that was the subject of the claim or the complaint, then it was required to be reported. And this significantly increased the number of filings since May 2009. The other thing, again, just historically, there used to be a rule, and I get this question all the time, there was a complaint on my record, then it disappeared, and now it's back. Well, in August 2010, FINRA, changed the rule to add historical complaints. So those were all complaints that had disappeared or been removed since 1997 due to different reasons like dismissal, denial, were back on. So it increased the disclosures on there. The next one, October 2013, expanded expungement guidance. That was really the beginning of really providing parties and arbitrators guidance on increased participation and giving them guidance on how they should conduct arbitration hearings. The next one, 2014, I think it's Rule 2081, prohibiting settlement conditions related to expungement. A lot of these are common sense, but there used to be stipulated awards and other agreements on expungement, and those are prohibited. So I always recommend, I don't discuss expungement at all until I receive a signed settlement agreement back. Again, FINRA has been updating the expanded expungement guidance and started in 2013. It was amended and updated in 2014, and then again in September 2017, allowing customer notification and participation. The national ad for broker check, it's just the progression. I was getting ready for work probably 6 years ago or more, and I was watching ESPN, and there was an ad for broker check on ESPN. So that kind of surprised me. So going forward with the timeline, and again, we're not going to cover everything. September 2015, kind of common sense, although it's subject to interpretation. What is a second request? You can't make multiple requests for expungement after they've been denied. There were different studies and task force put together to see what changes could be proposed, because PIABA was arguing that a large portion were successful and being granted. The expanded expungement guidance in September 2017 I referred to before, that really gave specific requirements on what, or guidance, not requirements, on customer participation, things that the arbitrators had to do, like review settlement agreements, allow customers to participate. And then, the most meaningful before that time was December 2017. Those were, the first substantive rule changes in a regulatory notice that have evolved, and that's where we are today. So going forward, to the next slide, that proposal from December 2017 never really went anywhere, and it was continued. It was resubmitted, and then on the eve of, I think it was May 2021, right when it was going to be approved or not approved, it was withdrawn, and that's where we are here today with the new rules that were approved by the SEC in April, and now a couple weeks ago, about a month ago, August 11th, announced an effective date of October 16th. And that, just to be clear what that effective date means, for customer cases, it applies to any customer case filed on or after October 16th, as well as any straight-in or expungement only requests filed on or after October 16th.
And then moving to changes.
Hold on, John.
Oh, you've
before
got to
we
do your
get-
code. Sorry, Joe.
Yeah, before we get into the changes, at the start of the show, we first code is the word rules. So just jot that down. Here you go, John.
Yeah, Thank you, Joel. So changes to request in customer arbitrations under Rule 12-805-A1, where the associated person is a named party, they must request expungement in the arbitration case or they lose the right to do so. So no longer can an associated person who is a named party sit back and wait and see the outcome of the arbitration and then try to make a standalone or a state-in request. If you're a party and an associated person, you've got to do it within the arbitration or you lose the right to do so. The request must be made in the answer that is filed or in any other pleading at least 60 days prior to the first scheduled hearing. The pleadings can, if you're going to not include it in the answer, make it a standalone request. It can also be done in a letter form, but the key is to make sure it's 60 days prior to the first scheduled hearing. And then expungement is only decided if the case proceeds to a hearing on the merits. If the case settles or it's dismissed during that period of time, then the associated person must file a straight-in request. And then Andrea, I think you have some additional comments on changes.
Yeah, absolutely. So I'm going to talk a little bit about on behalf of requests, and those are in Rule 12-805-A2, which applies when a financial professional is not a party to the arbitration. So the rule provides a mechanism for expungement to be sought by a party, which is generally going to be the brokerage firm, most likely that the associated person is associated with, and that firm will, or some other party will seek expungement on the financial professional's behalf, or associated person, as they may be called. So in order to do that, you have to submit a form requesting expungement on behalf of an unnamed person. So that has to be filed with the director so that the associated person can intervene. And by signing that form, the associated person will agree to be bound by the decision, and they'll agree to confidentiality of documents and information that's obtained through the arbitration. So the form is going to prevent the associated person from coming back later and filing a duplicate request for expungement, maybe claiming they were unaware of the earlier expungement proceedings. For these types of requests, the party who is requesting expungement for the unnamed financial professional or associated person has to appear in person or by video at the hearing. I see we have in the questions, we have a question about what, if any, attorney-client privilege would attach to a party to the arbitration who is coming in to seek a request for expungement on behalf of an unnamed person. And that is an excellent question. I'd love to kick it out to the panel and see what reactions you have. I mean, I think that certainly you could make an argument, or a strong argument, that the person representing a party would in fact have an attorney-client relationship with that associated person. I'd love to see what
that was my reaction as well, Andrea. I mean, certainly, this is new territory and it's not entirely clear, but that was my reaction as well, that, the language in that form talking about, agreeing to represent the unnamed person, certainly would make me, if I'm that lawyer, would make me feel like I am representing that person and have established an attorney-client relationship. If there's some situation where, you don't want that, I had to be very careful. And of course, in that situation, you can still go file that standalone case. So if that is, there's some sort of history or situation where it's not going to make sense or be a good idea to formally represent the FA, the AP, if that is a concern, I would avoid that.
Yeah, Joel, I think we have to look at the language of, I haven't seen the form. I really want to look at the language of this form. My interpretation of the rules is this form exists so the AP can't come back and get kind of a second bite at the apple, that the AP would be tied to that proceeding. not necessarily that it creates an attorney-client relationship. So we'll have to see how that's worded.
Yeah, and it uses agrees to represent the unnamed person in there, which I agree is kind of seems above and beyond the true purpose of the form.
Mhm.
But the fact that that language is in there.
Yeah.
Be a little concerning to me if I did not want that relationship.
Well, and certainly I think, it would be beneficial to have a representation letter sort of outlining what are the terms of the representation, what is it limited to, and certainly if the lawyer is representing the firm, which is what I would assume be the situation in most cases, the letter should probably talk about potential conflicts of interest to the extent those could arise.
Yeah. And I don't think the letter would preclude the unnamed person having separate counsel too, but
Right.
you'd want to, like Andrea said, really hash all those issues out and make sure you've got your I's dotted there.
Bill, do you want to look at that question regarding expungement and arbitration post-settlement, or the AP having to start over again?
Sure, you want to take that, John?
Yeah, I think again, if in an arbitration, if you are a named party, the way that I'm reading the rules is that you need to ask for that arbitration.
I think John is having a little trouble there. I think under the rules, if you're a named party to the arbitration, you have to request it in that customer arbitration. However, if the case settles, you're not
The
permitted to
expungement would
proceed.
leave settle, then the associate. Yeah,
If the case settles, the panel can no longer determine expungement. It has to be filed separately.
right.
Which leads us into the changes to the straight-in requests. So when the associated person files an arbitration proceeding seeking expungement. So one of the biggest changes is they have changed how arbitrator selection is done. Prior to the rule change, it's just like any FINRA arbitration under the industry code, where the parties receive lists of potential arbitrators, a public list, a chairperson list, industry list, and rank the arbitrators, and then are assigned arbitrators based on rankings. But the new rules do away with rankings. Instead of receiving lists of potential arbitrators, FINRA will just assign randomly selected arbitrators, and these will be selected from a special roster of arbitrators. To be on the special roster, the arbitrators all have to be eligible public arbitrators who are eligible to serve as chairpersons. So this is going to be, more experienced arbitrators. They also, in addition to having to be qualified as chairpersons, they have to have served as an arbitrator through award on at least 4 customer arbitrations. So this is going to be a lot of experienced people who they all also have to complete the enhanced expungement training that FINRA is providing. I'm sure if you have any FINRA cases with arbitrators right now, you have received lots of notifications with arbitrators updating their disclosure reports that they've completed this. A lot of them seem to be doing this in the past couple of months. So FINRA will randomly assign them, and then after you are assigned your arbitrators, you cannot stipulate to remove them. You can only remove them for cause. So FINRA has said that the reason for these changes is to prevent the associated person and the member firm from collaboratively seeking to influence the outcome of the expungement request through arbitrator selection. So this should be, this is a significant change. I think as it stands now, you can, if you're handling an expungement, you can see the arbitrators who are likely to grant expungement, rank them highly, and there's not going to be any more of that. They're going to be randomly assigned. So there are also new time limits. So for arbitrations or litigations, when a associated person is seeking to expunge a disclosure related to an arbitration or litigation that was filed prior to the rule changing, those must be filed 2 years after the close of the arbitration or litigation. If they are seeking to expunge a disclosure related to a complaint that did not involve arbitration or litigation, those have to be filed 3 years after the reporting of the complaint. There is a grace period. So, and the grace period does not apply. So once the rules go into effect, any disclosures that are more than 6 years old are eligible under the eligibility rule 13206 that says no claim is eligible for arbitration under the FINRA code when 6 years have elapsed since the event or occurrence giving rise to the claim. So anything more than 6 years old cannot be filed. But if they're less than 6 years old, then there's a grace period for after the rules go into effect. There's 2 years to file straight-in requests for expungement, seeking expungement of litigation disclosures, and then 3 years to seek expungement for disclosures related to complaints.
So another big change is the fact that regulators can now get involved formally in the expungement process. So new Rule 12805B provides that state securities regulators will be notified within 15 days that expungement requests are received. And FINRA will make available to state securities regulators relevant documents that relate to the expungement proceeding, and the regulator now has the right to participate in the hearing. So they can introduce their own evidence, they can cross-examine witnesses, and they can present opening and closing arguments. So obviously a big change in what you can expect when you're pursuing expungement. I will say leading up to this change, we've definitely seen an uptick in state securities regulators' interest and participation in expungement proceedings. I know that I've handled some cases that involve regulatory participation, as others have on this panel, and I've spoken with state regulators about the issue. My experience indicates that there are going to be very few expungement proceedings that regulators would want to get involved with. You've got to think about the resources that they have available and their ability to devote time and attention to expungement proceeding. And frankly, I doubt there's going to be much desire on the part of the regulators to participate unless the expungement touches on one of their regulatory priorities. Now, that being said, there's another force at play here, and that's really PIABA, because PIABA drove this amendment. They're kind of the force behind what we see here. And PIABA's position is that many expungements occur after the underlying hearing, so the claimants don't generally participate, and expungement requests are often unopposed. So what this rule change may effectively do is get the claimant out of the mix and allow PIABA via state securities regulators to provide what the rule proposal called meaningful opposition to help create a more complete factual record for the panel. So, again, we still have this issue though, like regulators have very limited resources as things stand now, and PIABA's solution there is to basically jump in and assist the regulators, presumably to try to potentially block the expungement request. We've seen members of PIABA make public statements offering their services to regulators to assist them with this process. So this, remains to be seen, like where this will go and to what extent their involvement will be. But David, share with us your experience here. I know you've had some as well. And you're on mute, so.
I was going to say, we have to wait and see what positions. I've had some interactions with regulators on expungements and confirmations, but I think it'll be, really limited to maybe unique circumstances or situations that focus on customers that are located in that state, or if it falls under the regulatory priorities. But I do think it'll be the exception and not the rule going forward.
You also have to wonder if a regulator does get involved, what does that mean to the expungement request? Is there any arbitrator on this special roster who is going to tell a state securities regulator, well, that's a nice argument, but I disagree and I'm going to expunge this? Or is it going to be like a de facto veto power for the regulator to shut down any expungement request they want? No answer to that question yet, but interesting to think about going forward.
I
For
think
sure.
sorry, Andrew.
Yeah, I mean, I think we're definitely going to see how this emerges as a trend. And I think that, given the very strong statements and involvement in this process that PIABA has had, there are going to be opportunities as you are defending an expungement, if a regulator does get involved, to potentially highlight some of that, maybe depending on who the lawyer is, who is assisting the regulator, just sort of shedding light on that relationship, potentially if there's press around it. You definitely have arguments to make. I wouldn't say it's a foregone conclusion that you're going to lose the expungement, but it, of course, puts it in a whole different light, creates a different dynamic than we've seen before, for sure.
Yeah, and Joel, I would expect that it's going to really follow a state by state. I think states that are reasonable in their regulatory process and what they do with their State Securities Act for the protection of customers or investors within their states, or activity emanating from their states, I think they'll continue to be reasonable and take a reasonable approach. I think perhaps some activist states and some activist state securities agencies are going to take this as an invitation to potentially come in and as Andrea mentioned, a possibility, try to direct the expungement hearing, from the state regulator standpoint. And it points out to the real change relative to FINRA appointing the 3 arbitrators and not being able to remove them, and coming off that list. So I think it's gonna be a lot that we're gonna see within development, so we're gonna have to watch.
Yeah, for sure. And I think, a shameless plug, but our firm definitely has a lot of relationships with state securities regulators, and of course, definitely with PIABA attorneys as well. So you would hope that you would be able to appeal to their sense of reasonableness, even though it might not be your sense. But, those conversations sort of behind the scenes, I think will be critical to just understanding what is their regulatory priority, if any, and, the situation.
Yeah, in my experience with state securities regulators and expungements to date, it's pretty limited because I think it's been an unusual situation. But like you said, Andrea, more of an uptick recently. But my experience has been so far that they, reach out, ask for information, maybe ask for some documents, maybe ask for a phone call or two to get their arms around it. And in the situations I've dealt with, they've been very reasonable and ultimately walked away without, objecting to the expungement or fighting it in any way once they got their arms around it and didn't disagree with, the positions we were taking. So, it's probably naive to think that that's how it's going to go each time forward with this express invitation and the formal rules inviting them to participate. But it does give me at least some hope that it will continue to be a reasonable process and not, the veto sort of power that I referenced earlier.
There's certainly hope.
All right, let's move forward to some other procedural changes.
Yeah, so there are other procedural changes to the straight-in requests. First is that they have to be filed under the industry code. They have to name as the respondent the firm where the associated person was associated at the time of the events giving rise to the dispute. So this will affect associated persons who, if they are seeking to expunge multiple disclosures, so say they have 3 disclosures that they want to expunge all at 3 different member firms, and they are currently at one of those member firms. Under the old rules, they could get away with naming just their current firm and not naming their former firms as a respondent, but now they're required to name all of those firms. There also are significant changes to customer involvement. So under the old rules, of course, customers receive notice of the expungement hearing, but that's kind of where, and they can attend, but that's kind of where it ends. There's no, they don't receive notice of any pre-hearing conferences or anything like that. But now under the new rules, customers will receive notice of pre-hearing conferences, and they'll be allowed to attend those. The associated person will have to provide a current address for the customer. If they don't provide that, then their expungement request is deficient. When the customer is providing notice to the customer, they also have to include language that encourages the customer to attend and participate. Now they just have to provide notice of when and where the hearing is, but there will be language encouraging them to participate. And the director will also provide the customer with access to all of the documents. So now the customer can attend, but they don't have access to the portal. I had an expungement hearing where a customer attended, and he was a disbarred attorney who wanted to cross-examine the claimant, but he didn't have any of the documents, so he couldn't really do much. But now with the rule changes, they'll have access. They'll be able to participate more and have access to all the documents.
What's the panel's experience with customer participation? Obviously outside of a hearing on the merits that involves a request for expungement, but if it's a standalone case or a post-settlement expungement request, how often are customers participating now?
Yeah, I don't know if we've seen stats. I would say maybe customer participation, maybe 10% of the time, maybe a little more. I think certain maybe products or investments might encourage customers to participate more, maybe depending on the size of losses, something like that. But under the current rules, they have to be provided notice and an opportunity to participate. And when I serve, I usually provide them a copy of the expanded expungement guidance so they know everything that they're allowed to do. But most of the time, if they do participate, it's without an attorney, although they have a right to be represented. We'll see if under these rules, FINRA is going to be the one who's actually sending the notices to the customers. And we'll see, hopefully we can see what the language is. But I think, the encouraging nature of FINRA to participate may increase that participation.
Other panelists, is that consistent with your experience? My number, I'd probably say less than 10% to David's number, but not a whole lot different than his answer. Is that what you guys see as well?
But that's what I've seen till, especially in a settlement, context. The customer has resolved the claim, and they're most reasonable customers who have a legitimate claim are ready to put it behind them. They're ready to move on, and this just continues going. So I think that's sort of some of the dynamics behind it. But that's been my agreement. We have one going on right now, though, where we secured an eligibility dismissal from the panel, and the customer and the customer's counsel has given every intent that they intend to participate in the expungement hearing and basically hijack it to where they're going to put on their case in chief on the merits that they did not do because of the eligibility ruling. And in addition, because they haven't proceeded to court because of limitations. So, you know, we're going to follow that one. Obviously, I think a lot of it's going to have to do with how the arbitrators govern the proceedings. And I think that that's what a lot will come down to.
Anyone have an opinion as to how much these changes will increase customer participation? I mean, if we're talking about a 10% roughly baseline, you know, does allowing them to attend the pre-hearing conferences and giving them documents and having the notice come from FINRA, those, I mean, do these changes, are they going to be meaningful, do we think?
I don't think so. I mean, I think the same incentives for customers are going to apply that, you know, you guys mentioned, which prevent them from having a desire to participate.
Yeah, that's where I come down to, Andrea. And one of the Q&As raises an interesting point in terms of the current address. I know that's something that can be difficult, you know, now, particularly if we're talking about a case that maybe was filed some time ago, or the person left the firm, you know, having to provide a current address to avoid deficiency could be problematic. And the question specifically was, what if the customers passed away? Has FINRA offered any guidance about that particular scenario? If the customers passed away, do we have to provide an address at all?
Yeah, I've read the rules. I haven't seen anything on that. What we usually do is, you know, serve the customer, or in my cases, if I find an obituary or a public record, I'll provide a copy. What I anticipate FINRA may do is, if we notify FINRA when we're providing the most recent address, if we provide that information that the customer is deceased, I would anticipate that FINRA would convey that information to the arbitrators and allow them to consider what impact, if any, that should have on the proceeding.
Agreed. And yeah, that's part of our normal process now, is to look for an obituary, or a lot of times through public records databases, we can pull a death certificate or something along those lines and submit that to the arbitrator.
Yeah, and I would think more often than not, the executor or the administrator of the estate would be really disinclined to proceed forward. But that's just you know, it's speculation, but it's based on experience. You know, I still don't think it would change. I think it's going to come down to whether a particular customer has a vendetta or not. And I don't think the rules are going to provide a broader opportunity for a customer that might wish to keep pursuing it. But otherwise, I don't think it's going to change the number of customers who may challenge a expungement.
Few more procedural changes here.
Yeah, changes to applicable to both types of request, both within the arbitration claim and the straight-in request. Again, unanimous decision of the 3 arbitrators is going to be required. A request may not be withdrawn. So if you start a request and you feel like maybe you drew a particularly hostile panel, you're not going to be able to withdraw the request and then try to refile it. Associated persons must appear at the expungement hearing in person or by video conference. And, you know, that is going to apply more, as we talked about earlier, on the behalf of because most associated persons want to be there and they want to tell their story. We talked a minute ago, panels can see documentary, testimonial, or other evidence from the firm or the AP. That's going to be a big change depending upon how aggressive or how active a particular panel or panelist may be wanting further information than what has been provided, by the associated person or within the pleadings. And if a customer obtains an expungement of a complaint, if the AP obtains an expungement of the complaint and then the customer files an arbitration claim, the prior expungement award is not admissible in the customer arbitration. And I have not seen exactly how FINRA intends to resolve this, whether they intend to add the arbitration claim back and require a second expungement opportunity after a claim is resolved or awarded. And that's something we're probably going to need to continue to follow and look at.
Yeah, and Joel, just to jump in on that one, I was actually at a hearing last week. It was a contested in-person expungement hearing that's going to be multiple days. But one of the panelists who disclosed that he had recently received the enhanced expungement training specifically requested documents that he wanted to see. The documents were completely unrelated to the factual allegations, unrelated to the expungement, but he thought, he has the right to request them and he wants to see them. I then stipulated with the other side after break that the documents were not relevant, but we were happy to provide them. And he agreed, well, if the parties agree that they're not relevant, I don't need to see them. So I just wanted to share that. I think arbitrators may be more active in requesting documents that they want to see, whether or not they're actually relevant.
I guess the enhanced expungement training didn't include the effective date for that arbitrator to know when he can make the request like that. But I've had arbitrators ask for documents. I could think of several times just off the top of my head in an expungement only setting. And, it's not part of any formal rule, but what are you going to say? I mean, of course you're going to give them what they ask for. And I think it's the same situation as the guidance, the expanded guidance on expungement that's been, on the FINRA website for years now. It's now formally part of the rules, or will be formally part of the rules. So, that sort of underscores the fact that before it never was part of the rules and there was no formal requirement to follow that guidance. But, what are you going to do? Of course, you're going to follow that guidance and adhere to it as best you can and give arbitrators, those boxes to check. But, it wasn't a formal rule until, coming up.
Yeah, Joel, and that's a good point. So we saw through the timeline, there were 3 different iterations of the expanded expungement guidance. And FINRA and arbitrators basically treated that as a rule, but again, it wasn't a rule, it was just guidance. And but if you know that the arbitrators are treating it as a rule, you try to follow it. But now the new rules codify the expanded expungement guidance, so it will be rule.
And John, this last bullet point here that you referenced, any rationale to that? I mean, to me, it seems bizarre and capricious. I mean, why in the world wouldn't you be able to reference an expungement award on the same subject matter in a subsequent arbitration?
I think the rationale behind it would be if the we've all experienced, I'm sure everyone participating with us today have experienced, where there's been a customer claim and simultaneously FINRA or perhaps a state is reviewing the matter and reviewing the activity of the associated person. And this recently happened with us. We we received a letter from FINRA after OTR and everything else that enforcement was not going to take any further action. Well, the rules within the customer code already state that you cannot introduce that within the arbitration proceeding. So I think on the basis of that rule, it is the idea that if something, along the line before this claim gets filed, presumably while it's a complaint or something that's showing on a U4 or U5 and you get it expunged, you can't come in and say, look, a panel already took a look at this and said it ought to be expunged, therefore it's a bad award or it's a bad claim. My guess is that's the rationale behind it. Is it similar to any type of regulatory determination other than an adverse one, relative to an associated person during a claim?
I accept that reasoning, even though I don't like it. And that's really the conclusion of the substance of the presentation. I want to ask one final question of the panel. We've talked about unanimous decision of 3 arbitrators, the new time limits, a whole bunch of different procedural requirements, regulator involvement, the random appointment of arbitrators. What do you guys think is like the biggest takeaway here? Like what's going to impact other than just sort of the logistics and process, but in terms of the decisions themselves on expungement requests, what do you think is going to have the biggest impact going forward?
Well, I think all these new rules are just, I guess, additional obstacles in the way of expungement. But if you have a good case and you have a good financial advisor who has a good story to tell, and hopefully you have good documentation, and the individual deserves expungement and can satisfy the rules, then it should be granted. But this certainly will make it more challenging and with additional obstacles. The biggest one, besides just the eligibility period being much shorter, I would probably say the arbitrator selection process. SIFMA had been pushing back. Why should the arbitrator selection process be any different in this kind of case than others? But FINRA has made the determination to randomly assign arbitrators. So that'll be, I think that's a big change.
Agreed. I think that's a good point. Why should this be, different than any other? There's also, the fact that mutual agreement of the parties doesn't mean anything in this context either, which is sort of a central component, I think, of the FINRA normal arbitration process. So interesting stuff. Anyone else have anything on that?
I think definitely those are the 2 things, the time limits, and then the arbitrary, the way the panel is going to be constituted. There's no question about that. That's going to be the biggest change. And then it's going to, I think too, whether we're going to see more filings in court out of FINRA arbitration because of some of these rules. I think that's going to bear watching.
And then finally, panel, if anybody has it, there's several questions in the Q&A right now that we're not going to be able to get to all of them. If anybody wants to hit one real quick, go for it. Otherwise, we'll follow up with you after the presentation. And while
Joel, there's been one in there for a while about whether these new rules apply to registered investment advisors or registered investment advisor agents.
right.
If they're duly registered, then they apply, but FINRA will not voluntarily grant the forum for expungements for RIAs. I've seen them be rejected in the past. So if they're registered with FINRA, then it applies and they can go forward. If it's just an RIA, FINRA won't grant the forum.
Thanks.
Hey, there's a request if you could give the code again, Joel.
There we go. Right on cue. Code number 2 is FINRA. So we got rules and FINRA for the 2 codes. And we're right on time, maybe a minute over. So appreciate everyone logging on today. You'll get the email with the survey where you enter the codes to get your CLE credit. Thank you and appreciate it.
Thank you.
To everyone.
Thanks, everybody.